High Court rules on Force India confidentiality or copyright claim. The High Court has upheld a claim by Force India brought against various parties for breach of confidence and for infringement of copyright works belonging to Force India, awarding the F1 team damages of €25,000. However, the court also ruled that Force India must pay to Aurolab, one of the defendants, €846 in respect of monies owed pursuant to a development agreement between the parties. Force India entered into a car development agreement with Aerolab. Aerolab and Fontech specialize in aerodynamic and secreted confidential computer aided design files. CADS, pursuant to the development agreement. After the agreement was terminated, Aerolab and Fontech commenced working for Lotus and used the Force India CAD files as their starting point. It is common practice for aerodynamists to use existing CAD files in order to save time. The question for the court was whether or not this act was a breach of the Force India or Aerolab contract and or an infringement of Force India's copyright. The decision. The judge ruled that Arab and Fontech had acted in breach of confidence, but only in relation to some of their car parts. One of the problems for the court was the Force India's claim lacked particularity in that the pleading didn't focus on prejudice dimension, so the judge had to analyze what was confidential and what was deemed to be within the public domain. Furthermore, although it was accepted that the aerodynamist had used the SCAD files as shortcuts, this wasn't the same as using the information to create the actual Lotus design. In relation to the breach of the development agreement, the judge held that Force India breached the agreement first by failing to pay monies due to Aerolab under the contract, and the Aerolab was therefore entitled to discontinue Force India's server access. It was also decided that because Aerolab had entered into an agreement with Lotus after the Force India agreement had ended, there could be no breach of the exclusivity clause. In relation to the copyright infringement claim, the court unsurprisingly ruled that the CAD files constitute a literary and artistic work. The original reproduction occurred in Italy, but further copies were made in the UK. This constituted an infringement, but again, principally because of the lack of particularity of the pleading, it was decided that the infringement only related to some of the car part. The glaring aspect of this case is that Force India won the argument that its copyright had been infringed, but that the information had not been misused to the extent that it appeared in the Lotus design. As a result, the court awarded damages by estimating a fair fee the parties might have agreed to allow Aerolab to use the CAD files as a starting point when it commenced work for Lotus. The other glaring aspect of this case is that the €25,000 awarded to Force India was set off against the monies due to Aerolab under the development agreement, which was just under €900,000. When legal costs were factored in, the litigation cost Force India considerably more in cash outlay than it gained. There was clearly a strategic element to this claim, and it was inevitably as much about protecting Force India copyright as it was about leveraging a better deal on monies owed under the development contract. However, the case demonstrates that when it comes to infringement of copyright and misuse of confidential information claim, it is vital to plead the breaches and infringement as preciously as possible. Sport short. Nike shoes Reebok over Tebow product. Nike has brought a claim against Reebok for allegedly improperly introducing news product bearing the name of star NFL quarterback Tim Tebow. Nike recently signed a 5-year deal as the NFL exclusive provider of on-field apparel for the NFL, and it claims only it is licensed to use Tebow's name on merchandise. Nike stated in its claim that Reebok has no authorization from Mr. Thibault or anyone else to use his name or other identification on such New York Jazz product. Nike is seeking unspecified compensation and punitive damage from Reebok, including an account of the profit from any sales of Thibault related apparel. Thank you.